to Legally Speaking with me, Tarun Nangia. Today we commence our part 2 of a very, very interesting topic. The topic being whether pendency of investigation is being used as a tool by agencies to deny bail. Also, whether default bail under Section 167/2 should be curtailed only because the investigation is pending. This is very important from the point of view of the accused and the litigators who are litigating in court. That every time there is an opportunity for bail, there may be a submission by the agencies that more investigation is required, and in the sense, bail gets denied to the accused without even him being convicted. So he gets to spend a lot of time in jail before he's even been convicted or his conviction is set aside. Either of the cases, but it concerns liberty, and that's why we discussed today in our part 2. May I welcome Justice Iqbal Ansari, sir, has served as a Chief Justice of Patna High Court. Good to see you, sir. I have with me Advocate Manmeet Singh. He's Senior Partner with Saraf and Partners in the Dispute Resolution Practice. Good to see you, Manmeet. I have with me Archit Singh. He's Partner with Circle of Counsels, a law firm specializing in financial crimes. Good to see you, Archit. At the outset, let me request Manmeet Singh, Senior Partner, Saraf and Partners, to make his introduction on this topic before we move ahead. Over to you, Manmeet.
Thanks, Tarun, for having me on your show. So, as you're aware, that this is a burning topic, and the Supreme Court had given a judgment recognizing that the right to get default bail is an extension of Article 21, and therefore, for that reason, writ petition would also lie, including under 32, for the purposes of getting bail in case the same is denied. Now, subsequently, there have been 2 orders of Supreme Court which have caused certain concern as to what is the direction in which this jurisprudence is headed. Now, as you are aware, that very often agencies are not able to complete investigations within the stipulated time, and therefore, as the Supreme Court had said, that in all such cases, bail will be given as a matter of right, and subsequently, multiple applications got moved before various courts, relying on this judgment, seeking the grant of default bail. However, this matter was mentioned by CBI and ED, and the government said that they are proposing to file a review. And in the meanwhile, a recall application was moved, basis which Supreme Court has passed an interim order that this order or this previous judgment of Supreme Court shall, wherever this is cited, those applications will be deferred. The central government union had asked for this judgment not to be relied upon, but since this continues to be in operation, the order what got made by Supreme Court was that these applications would be deferred. Now, therefore, the question which arises is that what happens in the interim period. In the interim period, unfortunately, as things stand, the net effect is that this Supreme Court judgment will not operate as a precedent for the time being. These applications will be deferred. And obviously this causes concern because in various, particularly financial crimes and economic crimes, where investigation, we have seen investigation not getting completed within the requisite time period, then bail becomes a challenge. And you have seen this in multiple matters which are ongoing. Now, this does cause concern because at the kind of the number of matters which are getting now initiated on a daily basis, there are FIRs getting filed by agencies in large matters on an everyday basis. Now, very often what we see that the process becomes the punishment. And obviously, then that is not the intention of the law, that is not the mandate of Article 21, and therefore there needs to be a balance. How that balance is drawn is, I think, the key question that the court will have to consider.
Okay, point well taken. Thank you for that opening comment. That was Advocate Manmeet Singh, Senior Partner with Saraf and Partners. Let me go to Advocate Archit Singh, who's partner with Circle of Counsels. He takes care of the financial crimes practice in a sense. Good to see you, Archit. Your opening comment.
Thanks, Tarun. So let me start by not going into the present day scenario, but let us start by actually looking at how this law actually came about and what were its developments. See, there was a point in time wherein a person was considered guilty unless proven innocent. We did have those days. But as time evolved, as democracies evolved, the right of an accused person also evolved over time. So it started by a simpliciter that you cannot be held for more than 24 hours. See, the rights of investigating agencies started getting balanced out with rights of an individual. Now, naturally, 24 hours is not a sufficient time period within which a person can complete an investigation, especially in today's time. This got extended to, say, 15 days. Okay, fine. You can't complete in 24 hours, up till 15 days, but you can only hold a person in custodial interrogation. So, but thereafter, even this was considered insufficient. And eventually, a parameter was evolved wherein what was laid down by the law was that up till 60 days in an offense which concerns a punishment up till 10 years, and anything 10 years, life imprisonment, or even death penalty, a person who is under investigation cannot be held for more than 90 days in judicial custody. So this includes the first 24 hours, 14 days in police custody, and thereafter your 45 days or 65 days as it may be, 75 days as it may be, in custody. Now, this is very important because what is happening over time is that an investigating agency will come to court. They will say, I have concluded in my investigation, qua person X, but there are 10 people in this investigation. So let this person now remain in jail because I've completed investigation against this person. But I am yet to complete my investigation in totality. Now, Tarun, there's something that is very important in criminal jurisprudence. That is, an investigation is that of a commission of an offense and not that of an individual. Now, merely coming to court and saying that I have completed my investigation against one particular individual, that is why they should be denied their liberty. But at the same time, Lordship, I am not even in a position to start trial because I still have to complete investigation. It leads to a situation of absolute absurdity wherein the intent of law is thrown out the window on a mere technicality that I have completed investigation qua one person. And I don't think this can be substantiated in law.
Okay, thanks for that argument, Archit. I'll take this point to Justice Ansari. Sir, your opening comment on this issue.
You see, Tarun, this debate is not new. It has been there for a long time. But of late, because of the number of sensitive cases has increased, that the debate has become more prominent. The duty of the court is to balance the need for liberty and the need for investigation. And that balance can be properly struck by the court if it is appropriately experienced and knowledgeable. Unfortunately, the courts have developed the tendency of denying bail because it is safer to reject bail. If you reject bail, nothing happens. If you deny bail, 101 questions are asked. This is something which is not in 167(2) or in any of the debates, because no court will say that I am not giving bail because of the matter, because the matter is sensitive. But the fact of the matter remains that if the matter is sensitive, that in that event, to get bail is really, really difficult and tough. Now, as far as investigation agencies are concerned, as posed by you, the investigating agencies are trying to take advantage of the pendency of investigation. But when a question of pendency is raised before the court will have to say and determine whether the time which had been given to the investigating agency had been effectively and properly utilized by the investigating agency. If you have not utilized it, then you can't ask the court to give you time and by denying bail to the accused, whoever has been apprehended. That is one thing which we should bear in mind. The second one is that if the investigation is not complete for one accused, as Mr. Archit Singh is saying, and at the same time we have to bear in mind that an investigation is not against an individual, but this is in respect of an offense. So in that event, basically it is for the court to determine if the court is alert and effective. If the court understands the game and can control it, then in that event there is no room for any complaint. But if the court is not doing its duty, I must say, in the manner in which it ought to do, then in that event the questions are bound to be raised and fingers are bound to be raised.
Okay, point very well taken. I'll take this to Manmeet Singh, Senior Partner, Sarafin Partners. Manmeet, two things: escalation of bail matters right up to Supreme Court, time lost in the interim. How do you see the scene for the accused? Because it is rarely that in other countries we see such a scenario where bails get listed before the Supreme Court. And then, of course, to get a hearing is a little difficult. Now, of course, it's more liberalized. More bail cases are being heard by Supreme Court. But yet, then again, it's one Supreme Court for the whole country. There is, of course, pendency there also. So your analysis of this issue.
I think Supreme Court has repeatedly said in the recent past, particularly, that bail orders should be short orders. It should not require detailed hearings. It should not require lengthy judgments. And Supreme Court has also from time to time been laying down guidelines on how bail is to be considered and granted and the parameters therefore. So I think Supreme Court is encouraging the lower courts to take a pro-liberty approach. And of course, as Justice Ansari said, in sensitive cases, sometimes lower courts can hold their hand back and be a little bit concerned about the consequences, because that's the unsaid thing. That if bail is granted in sensitive cases, then questions can get asked, and therefore matters eventually travel up. Such kind of matters eventually travel up. So, yet at the same time, you are aware the Justice Paul had issued directions pursuant to Satyendra Kumar Antil's judgment, asking the Registry of High Courts to report compliance. So, I think there is definitely a push from the Supreme Court, encouraging the High Courts and the lower courts to take a pro-liberty approach, so that fewer and fewer matters need to travel to Supreme Court. And Supreme Court certainly has been hearing many more bail matters now than it was earlier. So overall, I think the courts are looking at this entire issue in the right manner, I would say. And on this specific issue also, as Justice Ansari said, it is a question of balancing the rights of the accused versus the necessity and requirements of the investigation. And therefore, a balance would need to be drawn. The mandate of the statute does need to be respected. Now, of course, in matters such as money laundering, etc., where more time may be required for investigation despite best efforts of the agency, sometimes it may not be possible to conclude. There, the special statute can provide for a longer period. But the general approach still has to be to recognize the mandate that beyond 90 days, they cannot be custody.
Point and taken. Beyond 90 days, there cannot be custody. That brings us to this question to Archit Singh, a partner from Circle of Counsels. Archit, we see routinely that judicial custody sometimes extend to 3.5 years also, with no bail in sight. In many high-profile cases, the accused have been in jail for 3 years now. For example, in PMLA cases, the maximum punishment may be 7 years, but an accused may spend even 3.5 years in jail. What is the reason for this? Second, this whole, in a sense, reason given by the agencies of completing the investigation, is it also responsible for this 3-year custody?
Now, Tarun, let me answer this twofold question. See, one of the most important things that happens during an investigation at times is you determine that a person may have committed an offense. And with sufficient proof, sometimes without sufficient proof, you arrest a person. Now, naturally, at this point of time, a ticker starts clicking for the law that over 60 days or 90 days, as the case may be, a person cannot be kept in jail. Now, you're absolutely right when you say, because the two questions are interlinked, that the reason why an accused is in jail, Or let me actually rephrase it. Because our law actually determines and it states that a person is innocent until proven guilty. So an innocent person remains in jail for a very long time period because an investigation is partially completed. Now, you see, ideally, an investigating agency should be ethical and go to court and say, we could not complete our investigation within 60 days or 90 days, and let the person be put on bail. But not doing that and filing incomplete or limited charge sheets solely to deny the bail is a very bad practice. And to think it can be for any other reason is incredulous. Because there is no limitation per se under law to file a charge sheet. Let us remember that. The only limitation is that a person, if they have been arrested, cannot be incarcerated for a period of more than 60 or 90 days. So this flirts with a very dangerous notion as well, Tarun. That is the idea of a fair investigation. Am I getting a fair investigation once the agency has very purportedly filed a charge sheet to deny me bail and then continues for another 2 to 3 odd years to continue with its investigation? Now, I agree with Manmeet. There may be situations wherein there is a broad-based investigation, and certainly the investigation cannot be completed within due course of time given by the law. But then at least respect the law and the mandate and allow a person the liberty that they deserve as far as the law states they're innocent. And that is where I would like to conclude.
Thanks. I'll go to Justice Ansari for this. Sir, how does this law play out from Kashmir to Kanyakumari? Is it routine that we see that people spend extended periods without being convicted behind bars? And when a Supreme Court issues a bail order, does the message reach, for example, district courts in Northeast, in the South, in Chhattisgarh, various places? Are bails easy to come by, or people have to come to Supreme Court? Even then, after the Supreme Court sends a message that one has to be pro-bail or pro-liberty, the approach should be that.
I have not really followed your question. What you want to say?
What I say that when Supreme Court grants bail in a matter and tries to send a message that the district courts, the judiciary at the district level should follow a pro-bail approach. Does this message go across, or the system is so rigid that it is tough for this message to get across, and the litigants have to come to the Supreme Court for bails if the crime is of a serious nature or controversial, or the numbers involved are large enough?
Followed. Actually, in the Supreme Court grants bail, normally it is not resisted. The bail is granted and the man is released on taking the bail bond and surety, whatever is needed. The problem is that the Supreme Court itself is not consistent in matters of granting bail or denying bail. And because of the fact that we have seen many of the judges of the High Court and subordinate courts suffering because of this attitude of the Superior Court, that the people are not inclined to grant bail. Because when you want the people to stand for liberty and grant bail, then you must stand by them. And you cannot simply persecute them for the reason that they granted bail. This tendency developed about 10-15 years now by the CBI courts, basically when they started filing limited charge sheet. Limited charge sheet being the investigation is still not complete, but there is sufficient investigation to keep the accused under detention. There the courts have to be very vigilant and have to determine Are the materials collected by the investigating agency so much that you can say that the man behind the bar is guilty or should be kept incarcerated? That's a very sensitive question which the court has to decide. And if the court decides properly, I don't think if anyone is denied bail according to law, there is any problem. The problem will be where a person deserves to be granted bail and is not granted because of the fact that the investigation is still pending for a substantial part of the case. This is what basically it is the Supreme Court which has to generate that kind of feeling and confidence in the people. Because the complaint against not granting bail is against all, including the Supreme Court. So it is not that one who approaches the Supreme Court gets the liberty of bail. It's not that. And many times people can't even reach Supreme Court. So Supreme Court has to give that kind of a confidence to the judges all over. And if the judges become confident, I'm sure this tendency of looking for explanations to keep the accused behind the bar during the pendency of an investigation will definitely reduce, if not completely finished.
Thank you for that intervention. Now we will move to a round of closing comments. For bail jurisprudence to be appreciated overall, what needs to be done? We will start with a round of closing comments. May I request Manmeet Singh, Senior Partner, Sarafin Partners.
I would hope that the judgment of Ritu Chhabria is continued and not varied with. I think will go a long way in protecting the rights of citizens and following the mandate of Article 21.
Okay. Thank you for that closing comment. I'll go to Archit Singh, Partner, Circle of Counsels.
Well, Tarun, I think it's time that courts start asking investigating agencies the right questions. You see, questions make an impact. And questioning the agencies for their conduct, for their lapses, or sometimes just putting the questions out there brings out the true conduct. See, it is not necessary that always something is being done with malintent, but it is the court's duty to ascertain whether there was or was not any malintent. It should not come only from an accused to go and put up before a court that, listen, this is being done because of prejudice. No. Once those questions are put out in court by the courts, then it becomes a very smooth process, even for the superior court at times, to ascertain the reasoning behind the orders. So while the Supreme Court has very rightly said that orders need to be crisp, they also need to be well reasoned. So I think that is very important and need of the hour.
Okay, point very ask questions to investigating agencies. An order should be short and crisp, brief, is what Archit Singh articulates. I'll go to Justice Ansari for his closing comment on this important issue.
Tarun, the fact of the matter remains that bail is an important right. And the right of an accused, or for that matter, of every citizen or non-citizen to be granted liberty of doing what he wants is a very basic right. It's a human right, in fact. And when the courts jeopardize that right or curtail that right, then it is the duty of the court to be satisfied that yes, there are reasons, otherwise why the investigation will remain pending. I can understand some kind of a report is pending, some forensic report is pending, for instance, handwriting or whatever it is. But if you have to examine a witness, supposing a witness is not available in India, there will not be too many cases like this. So what is the reason for such long delay in completing investigation? The celerity is very important, and court has to ensure that the investigation is speedily concluded.
Thank you for that closing comment. today we learned a lot of things, including some fresh opinions. Actually, attitude of Supreme Court in granting bail being not consistent. Archit also articulated about questions that have to be asked of the investigating agencies. Manmeet Singh brought in his explanation about pendency of investigation. And overall, a fruitful episode that we will conclude the part 2 of our series on the issue of bails. Indeed, a very important topic, given that there have been many prosecutions in the recent times involving a lot of high-profile accused. But the question of bail, so to say, is not limited to high-profile people, but the impact is manifold, because many times high-profile people are employers. The companies get impacted, the employees get impacted, the ecosystem gets impacted. That's why it's important in that sense. I would like to thank Manmeet Singh, senior partner from Saraf and Partners, Archit Singh, partner from Circle of Counsels, Justice Ansari, for his time. Thank you so much, and I hope you enjoyed the series as well. Thank you so very much.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.